Joining me now is the retired former federal judge, J. Michael Luttig. He previously served on the Fourth Circuit Court of Appeals. Crucially, he helped this country avoid a constitutional crisis when on January 5th, 2021, he advised then Vice President Mike Pence that he did not have the authority to not certify Joe Biden's victory, contrary to what Donald Trump was pressuring Mike Pence to do. Judge, it's good to see you this morning. Thank you for joining us.
Good morning, Ali. Thank you for having me on with you this morning.
Judge, as you posted on social media after the hearing, the Supreme Court hearing, oral arguments on Thursday, one of your takeaways was that, quote, the court and the parties discussed everything but the specific question presented, end quote. I want to understand what you believe the specific question that the court should have been considering is and why it didn't succeed in addressing it.
Ali, the Supreme Court has now fiddled while Rome has almost burned to the ground, all but trivializing the existential threat to America's democracy and the rule of law facing the country. America's democracy and the rule of law are the heart and soul of the nation. It's our democracy and rule of law that have made America the beacon of freedom for the world for almost 250 years. Donald Trump's attempt to overturn the 2020 presidential election did drive a stake through America's democracy and the rule of law. His efforts to overturn the election both disqualified him from the presidency under the 14th Amendment, and it rendered him subject to prosecution for his offenses against the United States. Yet, 3.5 years later, the former president has remained unapologetically defiant. This week, he argued, as you said, to a receptive Supreme Court that he is absolutely immune from prosecution for his offenses. Indeed, and that all presidents must be absolutely immune from prosecution for the crimes they commit while in office, in order that he and all future presidents will be free to faithfully execute the laws without fear that they will be held accountable for the crimes they commit while in office. That this absurd argument is even being made before the Supreme Court is an embarrassment to the Constitution and to our country. This said, the Supreme Court seriously entertained the former president's argument earlier this week, clearly telegraphing that it was tempted by this preposterous argument, all the while barely even mentioning the narrow and only question presented to the court for decision, namely whether the former president may be prosecuted for the specific offenses he committed in attempting to overturn the 2020 election and remain in power against the will of the American people. Ali, there's not even an argument under the Constitution that a president of the United States is immune from prosecution for attempting to overturn an American election, remain in office, and cling to power in defiance of the will of the American people. The argument itself makes a mockery out of the Constitution, our democracy, and our rule of law. If a president can't be held accountable under the Constitution for this gravest of offenses against the country, then presidents can be held accountable for no crime that they commit while they hold the office of the president of the United States.
So, Judge, we often have you here as somebody who understands the law and the Constitution and electoral politics. You're an expert on that. But I want to just ask you now as a judge, if you're a judge considering a case, how do you draw the line? If you're one of the Supreme Court justices, how do you draw the line between trying to use hypotheticals to establish the boundaries of what the Trump team is arguing versus discussing the very specific things that you're talking about? Donald Trump is accused of doing X, Y, and Z. We can talk all we want about the hypotheticals of what a president should or should not be allowed to do, but as you state, he is accused of these things. That in itself is disqualifying, and the conversation about what presidents can do for all of eternity might be a different discussion.
Ali, it's fundamental to the judicial process that a court decide only the issue that's before it and no other issue. In this case, there is a pristine clear issue of constitutional law before the Supreme Court of the United States. That is the question or the issue that I've just framed for your audience. The Supreme Court this past week barely discussed that straightforward, clear question. It discussed everything but that question. So it resembled a law class, a conversation in a law class about all of the possible crimes that a president could commit while in office, and what would be the consequences of prosecuting that president for those offenses. Again, almost never discussing the single issue in front of the court. Now, how does a court decide the issue before it? It applies the Constitution and laws of the United States to that specific question and that specific question only, without regard to the political or other consequences of the court's decision. Here, the Supreme Court of the United States should have spent its entire 2.5-hour argument on whether the former president is immune from prosecution for having committed the grave offense of attempting to overturn the 2020 presidential election and remain in power, notwithstanding the votes of the American people. Instead, of course, we never know what the court will do, but it seemed evident to all that the court will end up remanding the case to the lower courts, either the Court of Appeals in the first instance, or more likely the federal district court, who's going to sit and preside over the trial. If it does that, will most likely ask that court to determine which of the former president's criminal acts, constitute acts in his official capacity as President of the United States, and which constitute acts in his personal, private, or candidate status, if you will. These are decisions, frankly, that the Supreme Court should make itself in the first instance when it has the case before it. But again, it appears that the court will almost certainly remand the case to the lower courts for that fundamental constitutional decision. The result, I believe, is that the former president will not only not be tried before the election in November, it's likely he will never be tried for the offenses for which he's been charged.
That's the question I was going to ask you about what this does to the timing. One of the most talked about portions of the hearing on Thursday was Justice Alito's question regarding a stable democracy. Let's listen to both of these.
I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy?
So, Judge, this is one of those hypotheticals that doesn't address what's actually happening here, because the basis of Justice Alito's questioning ignores the fact that we're actually dealing with the case of the only former president in the history of this country who thwarted the peaceful transfer of power. So the case Alito's making, the hypothetical, is interesting, and I'd love to hear legal opinions and discussions on that. But that's not what Donald Trump is actually facing.
Well, Ali, I'm not so sure that's correct. That was a hypothetical question, but it was unmistakably a hypothetical question directed at the current issue before the court. So I was astonished by that question, as were many others. But I reason from that question that at least some members of the court are, their argument assumes that the prosecution of the former president is politically corrupt. And it seeks then a rule that would prevent all future presidents from prosecuting their predecessors for like crimes or even lesser crimes. The problem with that argument, if you will, is that would yield a rule that would immunize all future presidents from all crimes committed against the United States while in office. That simply can never be the law. But this Supreme Court is exploring exactly that possibility.
Judge, it's always enlightening to talk to you, sir. Thank you for being with us. Judge Michael Luttig is a former federal judge on the U.S. Court of Appeals for the Fourth Circuit.